Chapter 2, The Federal Role in the Child Support Enforcement Program. Introduction. Since the early 1950s, Congress has shown a persistent and increasingly forceful initiative to promote a viable child support enforcement program. Efforts to pass effective child support legislation began to intensify in the mid to late 1960s, culminating in the 1975 passage of Title IV-D, the current Comprehensive Child Support Enforcement Program. Prior to this time, Public Law, PL, 8997, which passed in 1965, legally sanctioned the use of Social Security records to locate parents, a process that many states had employed informally for years. Upon enactment of this legislation, states could gain access to Social Security records through the Social Security Administration to obtain recent addresses and places of employment of absent parents. Next followed the 1967 passage of PL 9248, providing states access to Internal Revenue Service (IRS) records to obtain addresses of absent parents. This law, which amended Title IV of the Social Security Act, included provisions that required state welfare agencies to establish a single unit whose mission was to collect child support and to establish paternity for children on public assistance. States also were required to work cooperatively with each other under child support reciprocity agreements and with courts and law enforcement officials. Nevertheless, by 1972, it was clear from the rapid increase in numbers of AFDC recipients that the 1967 amendments had not produced the intended results. In light of their relative ineffectiveness, the U.S. Senate Finance Committee, under the chairmanship of Russell Long, had begun working in early 1971 to compile data on AFDC costs and child support enforcement. The committee intended to use this information in developing new Social Security amendments to strengthen child support enforcement. A group of senators, most notably Long, Mondale, and Nunn, continued to push for a comprehensive child support enforcement program, despite unsuccessful attempts in 1972 and 1973. The senators apparently envisioned legislation that would define clearly the functions and operational parameters for the state agencies that had been mandated by law in 1967 to collect child support and establish paternity. Other desired outcomes were to strengthen the federal regulatory and oversight role, to establish parent locator services at the federal and state levels, and to establish funding standards and procedures. Despite repeated failures to get bills through both houses, the child support provisions that had been deleted from legislation a year earlier were incorporated into House Rule 17045 in late 1974. The provisions passed both the Senate and the House on December 20, 1974. President Ford signed the bill into law on January 4, 1975. As PL 93-647, the Social Security Amendments of 1974. Part B of PL 93-647 enacted Title IV-D of the Social Security Act, which created the Program for Child Support Enforcement and Establishment of Paternity. Since 1975, Congress has examined a number of legislative initiatives and, almost every year, passed bills that address such things as funding to states, additional child support collection remedies, and mandated state record-keeping and enforcement activities. Appendix A provides a chronological legislative history of Congress activities, including a thorough discussion of the Child Support Enforcement Amendments of 1984. Which embody the most comprehensive requirements on state child support enforcement practices since the program was established. The Federal Office of Child Support Enforcement, PL 93-647, required the Secretary of Health, Education, and Welfare, now the U.S. Department of Health and Human Service, DHHS, to establish a separate organizational unit to oversee the operations of state child support enforcement programs. This was accomplished through the establishment, within DHHS, of the Office of Child Support Enforcement, OACS. In a move reflecting the commitment of DHHS to the Child Support Enforcement Program, the director of OACS began reporting directly to the Secretary of DHHS in early 1985. Previously, the Commissioner of the Social Security Administration also served as the director of OACS. OACS's mission is to provide leadership in the planning, development, management, and coordination of the department's child support enforcement program and activities authorized and directed by Title 4(d) of the Social Security Act and other pertinent legislation. The general purpose of these programs and activities is to require states to enforce support obligations owed to children by locating absent parents, establishing paternity when necessary, and collecting child support. The specific responsibilities of OACS are to establish regulations and standards for state programs for locating absent parents, establishing paternity, and obtaining child support. Establish minimum organizational and staffing requirements for state units engaged in carrying out child support enforcement programs. Review and approve state plans for child support enforcement programs. Evaluate the implementation of state child support enforcement programs. Conduct audits of state programs to assure conformity with requirements, and, not less often than every 3 years, conduct a complete audit of these programs in each state and determine for the purposes of the penalty provision of Section 403(h) of the Social Security Act, 42 U.S.C. 603(h)(2), whether the actual operation of such programs in each state conforms to federal requirements. Assist states in establishing adequate reporting procedures and maintaining records of the operations of child support enforcement programs. Maintain records of all amounts collected and disbursed under child support enforcement programs and of the costs incurred in collecting such amounts. Provide technical assistance to the states to help them establish effective system for collecting child support and establishing paternity. Certify applications from states for permission to use the courts of the United States to enforce court orders for support against absent parents in interstate cases where a state has been non-compliant. Operate the Federal Parent Locator Service, FPLS. Certify amounts of past, due child support obligations to the Secretary of the Treasury for collection. Submit an annual report to the Congress on all activities undertaken relative to the child support enforcement program. Establish regulations and standards for federal financial participation in support of state child support enforcement programs. The organization of OACS. OACS is responsible for all program and policy aspects of federal, state, and local child support enforcement programs. To carry out this mission, OACS has been organized into the Office of the Director and 5 divisions: Management and Budget, Program Operations, Policy and Planning, Audit, and Information and Management Systems. The responsibilities of these divisions are discussed briefly below. The Division of Management and Budget directs the overall OACS administrative management support effort in the areas of budget, personnel management, manpower and organizational management, travel management, space management, and procurement. This division also administers the OACS State Grants Program. The Program Operations Division assesses state program performance and effectiveness by assisting OACS regional offices in the conduct of special studies and reviews, provides technical assistance to regional offices and states on operational aspects of their programs, develops guides, concepts, and procedures for use in program operations, provides management consulting services to state child support enforcement agencies. In addition, this division develops and issues various publications related to child support, including a monthly newsletter, and operates the National Child Support Enforcement Reference Center. The National Child Support Enforcement Reference Center provides technical information concerning program management, research findings, and other topics related to child support enforcement. The Policy and Planning Division develops and analyzes policies, regulations, and legislation relevant to the child support enforcement program, develops procedures for state plan review and approval by regional offices, reviews regional office recommendations of state plan disapprovals, develops long-range plans and objectives for the agency, conducts statistical analyses and research projects, develops, coordinates, and conducts evaluation studies, and designs statistical reporting requirements and methods for obtaining data. The Audit Division conducts program results audits of state child support enforcement programs at least once every 3 years to determine program effectiveness and compliance with the Social Security Act, makes recommendations to the Director regarding imposition of the penalty provision of Section 403H of the Social Security Act, 42 U.S.C. 603H2, develops and conducts administrative cost and other special audits, and develops guidance concerning audit procedures and standards. The Information and Management Systems Division develops and assists in the planning and installation of automated systems for use by state programs, provides consulting services and technical assistance to states on advance planning documents for 90% federal financial participation, reviews, evaluates, and approves requests for federal matching funds for automated state/local child support enforcement systems, conducts periodic reviews of state advance planning document installations, establishes and maintains automated system standards for the states, operates the federal parent locator service, provides computer services, automated system design, development, and maintenance services to OAKS, operates the federal tax offset system and the Project 1099 system, coordinates and monitors the IRS full collection process, and, in conjunction with other OAKS users, operates the OAKS Management Information System. The OAKS regional offices provide technical assistance to states in establishing effective child support enforcement programs, provide interpretation of child support enforcement program regulations to state agencies, provide assistance to state agencies in developing state plans, review and approve or recommend disapproval of state plans and state plan amendments, evaluate the implementation of state programs, and review state activities to determine legitimacy of claims for federal financial participation. OAKS projects and activities. The provision of technical assistance to states is a mandated requirement of OAKS. To this end, OAKS operates the FAPLS, produces program-related publications, administers research and demonstration projects, provides training and disseminates information to the public, and conducts audits of state and local child support enforcement programs. Each of these activities is discussed below. The Federal Parent Locator Service. OAKS operates the FAPLS by communicating with other federal agencies to find the current addresses and places of employment of absent parents. On receiving a request, the FAPLS checks records maintained by the Social Security Administration and the records of several other agencies including their Internal Revenue Service, Department of Defense, Veterans Administration, National Personnel Records Center, Selective Service System. Publications. OAKS disseminates news and information regarding effective program techniques and management practices through its monthly publication Child Support Report and its periodic abstracts of child support techniques. In addition, OAKS publishes the semi-annual Information Sharing Index, a listing of all child support enforcement materials, including research report, available from the National Child Support Enforcement Reference Center. OAKS conveys its policies and procedures, including proposed and final federal regulations, in action transmittals. Items of interest to state and local 4D agencies are conveyed through information memoranda. These last two publications are issued as necessary. OAKS releases data in tabular form, on a periodic basis, in a publication entitled Child Support Enforcement Statistics, and informs Congress of federal and state child support enforcement activities through the annual report to Congress. All these materials are available at no cost, upon request, from the National Child Support Enforcement Reference Center, 6110 Executive Boulevard, Room 820, Rockville, Maryland 20852. Research and Demonstration Projects. OAKS expends about $450,000 annually to employ contracts and grants for research and demonstration projects to add to existing knowledge and develop new methods and techniques. In addition, the Child Support Enforcement Amendments of 1984 authorize OAKS to award grants to encourage and promote improved interstate establishment and enforcement. These grants may be awarded to states beginning in federal fiscal year, fee, 85. Amounts authorized are $7 million in fee 85, $12 million in fee 86, and $15 million in subsequent years. In fee 83, Oaks funded research and demonstration projects with the following purposes: to quantify the national collections potential, to develop models for assessing and updating child support award levels, to develop standards for parentage testing laboratories, to study the effects of child custody arrangements on child support payments by absent parents, to develop alternative methods for obtaining financial and case characteristic data about absent parents, to research the costs and benefits of paternity establishment, to improve interstate child support collections, to investigate the practical aspects of modern paternity testing, and to study court systems to improve the collection of court-ordered support. In addition, Oaks funded various demonstrations of administrative improvements in child support enforcement case processing techniques, training and public information. In order to provide more efficient and effective services to states and to improve management effectiveness, Oaks has contracted with several organizations to train child support enforcement professionals in proven methods of operation and to interpret the program to interested outside parties and the general public. Included in this effort are the National Council of Juvenile and Family Court Judges, the National Institute for Child Support Enforcement, the National Conference of State Legislatures, the American Bar Association, and the National Governors Association. The services of these 5 organizations are discussed below. National Council of Juvenile and Family Court Judges. Founded in 1937, the National Council of Juvenile and Family Court Judges, NCJFCJ, is the oldest judicial membership organization in the nation. Council membership comprises judges, referees, commissioners, and masters, court administrators, clerks, attorneys, and others active in juvenile and family law may join as associate members. Membership services include continuing judicial education at the University of Nevada and other sites around the country, consultation and technical assistance, provision of state and regional training programs, and a variety of publications, including the Juvenile and Family Law Digest and the Juvenile and Family Court Journal. The Council also provides research consultation services through its research division, the National Center for Juvenile Justice, in Pittsburgh, PA. The training division of NCJFCJ, the National College of Juvenile and Family Law, NCJFL, conducts over 100 continuing judicial education programs annually for professionals in the juvenile and family court field in cities throughout the United States and on the Reno campus of the University of Nevada. In 1985, over 12,000 people were trained. The faculty is composed of judges as well as internationally and nationally known experts in the fields of juvenile and family law, child development, sociology, psychology, medicine, and administration. Since 1979, NCJFCJ has been providing child support enforcement judicial education under contract to Oaks. This includes presentations targeted to judicial participants at national, state, and local conferences, the incorporation of child support enforcement issues in courses offered at NCJFL in Reno, published articles on child support enforcement in periodicals targeted to the judicial community, and a 12-member Judicial Advisory Committee, which makes recommendations on child support enforcement issues. National Institute for Child Support Enforcement. The National Institute for Child Support Enforcement, NICS, was established in March 1979 to develop and present training courses tailored to the needs of federal, state, and local personnel participating in the child support enforcement program and to assist with technology transfer among the states. In its 6 years, NICS has developed 11 formal training courses and conducted over 500 deliveries to more than 10,000 child support enforcement professionals. NICS has developed 16 publications and distributed over 90,000 of them to the field. This publication record makes the Institute a major source of printed information on the child support enforcement program. The Institute's working relationship with Oaks and state and local programs also has facilitated the dissemination of information Through its lecture presentation series, institute staff and affiliated consultants have made over 175 presentations to audiences as large as 800 persons. Now beginning its 7th year of operations, NICS continues to offer training courses, materials development, and lectures for the Child Support Enforcement Program. In addition, a new technical assistance project will apply institute expertise in training development and delivery to help improve state training capabilities. NICS also will be offering seminars for new State 4D administrators and developing videotapes in support of various OAKS information campaigns. National Conference of State Legislatures. The National Conference of State Legislatures, NCSL, assists state legislatures in developing and enacting legislation beneficial to their child support enforcement programs. Toward this end, NCSL conducts research, provides information, and coordinates expert testimony concerning the experience of other states that have enacted similar laws. American Bar Association. The American Bar Association, ABA, has contracted with OAKS to operate a child support project as a component of its National Legal Resource Center for Child Advocacy and Protection. Under this contract, ABA provides training to attorneys, both inside and outside of the 4D program, produces related written materials, provides training to court and paralegal personnel on interstate support enforcement, and provides technical assistance to bar groups, legislative committees, state child support commissions, and individual attorneys. In addition, ABA has worked with NCSL to develop model legislation such as the Model Interstate Income Withholding Act. National Governors Association. The National Governors Association, NGA, provides a mechanism for identifying and resolving problems related to the development and implementation of national policy and a forum for addressing state problems. The association works with Congress on federal and state policy issues, which include the Child Support Enforcement Program. This relationship enhances the sharing of program knowledge among the states. Specifically, NGA has contracted with OAKS to provide a forum for identifying issues that need to be brought to the attention of top-level policymakers at the state level for action needed to implement federal law in state child support enforcement agencies. In addition, NGA develops and disseminates a variety of material on child support enforcement to key level managers and policymakers in the states. In addition to these contracted services, training and public awareness activities are conducted by OAKS central and regional office staff. Audits of state and local programs. OAKS audits of state programs significantly improve program performance by alerting management to deficiencies and by recommending more effective and efficient methods of operation. Prior to the FY86 audit period, OAKS auditors will complete state plan program results audits and systems reviews of all 54 states and territories. Beginning with the FY86 audit period, the auditors will begin using criteria that are related to program performance indicators as well. In order to assess states' performance on a results achieved, quantifiable basis, several initial performance indicators have been developed by OAKS in conjunction with state officials. These indicators are AFDC 4D collections total 4D expenditures AFDC collections total 4D expenditures AFDC 4D collections 4 assistance payments, minus payments to unemployed parents. Beginning with the audits for FY86, these indicators will be used to evaluate performance and, with the program results audits of state plan requirements, will constitute the basis for determining states' program effectiveness for purposes of the audit penalty. Beginning with FY88, 4 additional performance indicators will be added to evaluate performance. 3 regulations implement the new audit system. 45 CFR 305.98 defines the performance indicators. 45 CFR 305.99 provides for notice to a state of a finding by the Secretary of DHHS that the state's program is not substantially in compliance with program requirements and also provides for a corrective action period. And 45 CFR 305.100 establishes the sanctions to be applied against states found to be out of compliance and that fail to correct the deficiencies, based on the criteria contained in the Secretary's notice. The sanctions are applied by reducing the state's federal matching funds, as follows: not less than 1 nor more than 2% of such payments for a period beginning in accordance with the regulation not to exceed the 1-year period following the end of the suspension period. Not less than 2 nor more than 3% of such payments if the finding is the second consecutive finding made as a result of an audit for a period beginning as of the second 1-year period following the suspension period not to exceed 1 year. Not less than 3 nor more than 5% of such payments if the finding is the third or subsequent consecutive finding as a result of an audit for a period beginning as of the third 1-year period following the suspension period. When a state corrects the deficiencies within the corrective action period, the penalty will not be imposed.